Justice Barrett?
Let me pick up on that, Mr. Clement. This is, as Justice Thomas asked you at the beginning, both the free exercise and free speech claim. Who is he communicating to? God? Like, where's the speech?
I think he is communicating to God.
And so that would trigger the First Amendment protection.
Under both the free speech clause and the free exercise clause.
Well, I understand the free exercise part of it, but even if he's not communicating to an audience, so he's completely silent, he just takes the knee, that's protected speech, even if he's not trying to communicate to anyone around him, just to the Almighty.
Absolutely. It's
Okay.
expressive conduct, or speech.
Second question is to this coercion point. Let's imagine that Coach Kennedy runs a Young Life group, and he has many players, and many other kids in the school, but many of his players, because they really admire Coach Kennedy, come to his home for these Young Life meetings. And many of the concerns that Justice Kavanaugh is identifying are present. A lot of the players come because they think they're going to get more playing time if they come and show up and participate in this Christian youth group. I take it your position would be that that's entirely private speech, and even if there's a coercive component to it, that the school can have nothing to say?
Well, I think that if the school has a concern about that kind of activity, after-school activity, wholly off the school grounds, I think the way, if it really had a concern with that, it could try to deal with it through some kind of neutral policy. If it said, well, we're sufficiently concerned about that, we're not going to let any teachers have any kind of outside events at their house or something, then I think that would be a neutral policy. Somebody could try to test whether that's consistent with Smith or whether Smith's good law, but those are all different issues. But I think, another way that the school can deal with these kind of issues, if it's not pretextual and just designed to root out religion, is to have neutral rules that say, okay, like, we get it, there are some concerns. But the one thing I think that's clear from this court's cases is that you can't have a prophylactic rule that says, there might be some problems. And so the way we're going to solve the problem is to forbid a lot of protected speech. Ashcroft against Free Speech Coalition, among other cases, says that that's verboten.
And I guess I'm gathering from your response that you would treat that Young Life example as basically subject to the same kind of analysis as Justice Kagan's examples of, a disclaimer before class, this isn't instructional, or maybe it's before the bell, like Justice Sotomayor asked you before. Purely private speech, not endorsement. Nobody could mistake it for government speech. And any coercion would be, maybe it's there, maybe it's not, just as in the Young Life group, maybe it's there, maybe it's not.
I think that's right. And again, if there's a lingering concern, the option I think that's still on the table is a neutral rule that sort of avoids those situations. Because again, it really, as you sort of articulated, if there's a concern, it really isn't a concern that's specific to religion in any way, shape, or form. You could have the same thing for any after-school activity. If the idea is, well, people are going to kind of curry favor with the teacher and participate in that, then maybe you have a rule about it. But of course, you can have that already, right? Think you're going to get a better math grade if you go up for the math team. So at a certain point, the responsibilities of the school is to teach the important lesson that private speech is protected, even for teachers and coaches.
Thank you.
Thank you, counsel.